Hello and welcome to our session on the European Court of Human Rights on Child Protection and Children's Rights. The Court's case law on matters such as the child's best interest and children's right to participation is extensive, but is also sometimes incoherent. In particular, when we look at it from the child's perspective, it may be seen as problematic. The Court has the authority to exercise discretion, and the impact on member states' policies and practice is potentially huge. At the same time, the Court has become an arena for civil society and member states to intervene in cases before the Court to provide their view on how to assess principles and evidence. But what impact does this actually have on the Court's judgment? This and more is what we will explore in today's session. Welcome. My name is Jenny Krutzina, and I'm a senior researcher at the Center for Research on Discretion and Paternalism here at the University of Bergen. I'm the moderator of today's session, together with my colleague Katre Luhama at the University of Tartu, Estonia. Katre is a legal scholar and an expert on human rights. We have three wonderful panelists with us today. With us in the room is Karl-Harald Soek, who many of you will already know. Karl-Harald is the professor of law and dean at the Faculty of Law here at UAB, and he's one of the country's leading experts on children's rights and has written extensively about the decisions of the European Court of Human Rights concerning matters of private and family life protection. Next, we have with us virtually Marius Embeland. Marius is a lawyer at the Attorney General Office in Norway, where he has special responsibility for international law and human rights. In recent years, he has responded to the European Court of Human Rights on behalf of Norway in several child protection cases, and is thus an expert on this matter. Last but not least, Conor O'Mahony in Ireland is also here today with us virtually. Conor is a professor of law and deputy dean of the School of Law at the University College Cork in Ireland. Since 2019, Conor is also the Special Rapporteur on Child Protection for the Irish government. Welcome also to the audience in the room and online. It's a pleasure to have you all here. Just briefly about the format, we will first have three short presentations by our panelists in the order that I introduced them in. Katre will then give a very short summary of the main points and start the discussion with a question, and we will then open up for questions from the audience. People in the room can just put their hands up, and online, please use the chat function to indicate that you have a question. Okay, without much further ado, over to you, Karl-Harald.
Thank you. How much time do I have?
15 minutes, and we'll be strictly enforcing this.
Well, there's a freedom of speech, you know. Now I will try to keep my time. Thank you for the nice introduction, and this is indeed an important topic for the society, for the children, and for their parents. We are going to talk about child protection cases. It is about Article 8 of the European Convention on Human Rights, which in short states that everyone has the right to a family life. The state can intervene in the family life under certain conditions, and the crux of the matter is whether this interference is necessary in a democratic society. As many of you know, we have the European Court of Human Rights in Strasbourg enforcing Article 8, and there has been numerous cases about child protection cases since the 1980s. The first cases concerned Sweden, and I think this was an eye-opener for all the Scandinavian and Nordic countries. Human rights violation was something that was a problem in other parts of Europe, not in the Scandinavian welfare states. And there were cases against Sweden where the court found a violation because the Swedish authorities had intervened with the family life, and it was a violation, especially when it comes not to the care order, but how they were enforced. From a domestic perspective, the main case was Johansen versus Norway from 1996. It was a case even from Bergen, where the authorities took care of a child rather soon after birth. And then there were restriction of access, and the mother was also deprived of her parental responsibility. The court found then a violation not concerning the care order, but how it was enforced. The Norwegian authorities too soon came to the conclusion that it would be a long-term placement, and that affected the access rights and the parental responsibility. That was in 1996. And after that, there were some child protection cases against Norway, but rather few. But there were many against other countries. And of course, the time is too short to go into all the details. But it was not only from Southern Europe, but throughout Europe, and also some cases against Finland from the Grain Chamber, which also was interesting, but we don't have time to go into now. From 2016 and onwards, there were many complaints against Norway. It's difficult to kind of analyze why there was this kind of sudden rise in the application numbers against Norway. I guess it was a kind of increased awareness amongst Norwegian lawyers that this was a remedy that you could use. The first cases that was decided after this kind of rise of cases, the court came to the conclusion that there were no violation, except in one case, Janssen versus Norway, but that was rather kind of special situation, which we will not have time to go into here. Then came this Strand-Lobben against Norway. That was first decided by the court in Chamber. That is a decision by 7 judges. And the court was divided 4 against 3. And the majority came to the conclusion that there had been no violation. This case was brought before the Grain Chamber, and the Grain Chamber decided the case in 2017. And the Grain Chamber is composed, as many of you know, of 17 judges. The majority, 13 judges, came to the conclusion that it had been a violation of Article 8. The case concerned adoption, but it was, when it comes to the facts, it was rather similar as the Johansen case. It was a mother that was where the children were taken from her rather soon after birth. And in the year to come, the mother had settled again and had other children where the state or the government, the local authorities did not have intervened. In Strand-Lobben, the child was adopted after many years in foster care, and of course, this is rather kind of complex matter because the care order itself was not challenged before the European Court of Human Rights. It was the adoption order. But the court said that, well, we have to look into this matter as a whole. And the main issue, the court said, was that too soon the Norwegian authorities had said that this will be a long-term placement, and that had also affected the access, the contact rights, because the mother had only limited contact with her daughter. In addition, it was a kind of procedural issue, which I will return to later on. So that was very short about the case, and the majority of 13 judges came to the conclusion that it was a violation. The court was divided, where there was a fraction within the majority of 6 judges being more harsh in their critique of the Norwegian child protection system. After Strand-Lobben, there has been many cases decided by the court. And with 50 minutes, I will not use the time just to name the cases, but I will try to kind of sum up the core critique. And it follows the line from the Strand-Lobben case. First of all, the Norwegian authorities are too soon considering that the care order will be long-term. That also has an impact on the contact rights, the contact between the child and their parents. It is too short and too seldom. Most of the cases has concerned excess contact rights, but there has also been cases regarding adoption, like the Strandlobben, but the core element in these cases has not been the adoption itself, although it has also been criticized by the court, but it is this time dimension that the Norwegian authorities too soon are considering a care order to be a long-term placement. There has also been some cases concerning procedural elements, mainly that the assessment of the psychological expert has not been updated, but we will, I think that's interesting and of course something to dig into, but I think that we, at least in this discussion, will concentrate on the contact element. What is interesting is that the Norwegian cases has not addressed, or they have addressed, but there has not been found a violation concerning the care order. In many of the cases, the parents has claimed that the care order itself has been a violation of their human rights. The court has constantly said, as they did in the cases against Sweden in the 80s, that when it comes to the care order, the state has a wide margin of appreciation. Those working with the court knows that margin of appreciation doctrine is an important aspect of the court's case law. Even though that the state has a rather wide margin of appreciation, the court has in other cases stated that this is not unfettered, and there are examples that the court has stated a violation even when it comes to the care orders, especially when there has been an intervention against new laws. There is a kind of different approaches at the European Court of Human Rights compared with what has been the kind of traditional approach in domestic case law, where it is, if you go and read decisions by the county courts taking this kind of cases in the first instance, you see that almost in every case, the board states that this will be a long-term placement. But if you read the case law of the court, which is binding for Norwegian courts and boards, well, there you will see that the court is stressing that a care order should be a temporary measure. I think we should reflect on that, both when it comes to how have we developed in Norway a practice that is not going in the same direction as the European Court of Human Rights, but also to reflect upon the case law from the court. A child needs stability when they are under public care, and stressing this temporary dimension has also an impact on the child, which I think could be challenged and reflected upon. So for Norwegian parts, what shall we do now? After the cases from the European Court of Human Rights, the Norwegian Supreme Court has decided several child protection cases. I think without having the exact data, I think that in 1 year, there has never been so many child protection cases being decided by the Norwegian Supreme Court in chamber. And that is due to these many complaints against Norway. And we will not have time to go into all the details, but I will say, at least claim that the Norwegian Supreme Court has been rather loyal and has been following up the judgments by the European Court of Human Rights. But this does not mean that everything is fine in Norway. I think it's really important that we continue to discuss child protection cases. I think it's particularly important that we discuss the care orders, because the European Court of Human Rights has been rather reluctant to go into the, or at least to overrule the care orders. But that does not mean that there are not discussions that we should take in our domestic environment when it comes to the care orders. I think I've used my time, so thank you.
Thank you very much, Karl. So over to Marius Emmerlund.
Yes, good morning. I hope you can hear me from my office. Good. Thank you for your invitation and for letting me do this digitally. I have given my presentation a title, and I will share the presentation with you. Just give me a few seconds. I think we are there. Do you see the presentation now? Good. So just a disclaimer before I start, I have represented and still represent the Norwegian government in these cases, but my views today are not, I'm not conveying the formal views of the Norwegian government, just to state that at the beginning. I shall also say that I wholly subscribe to what Karl Harald just said, and I will just build on his presentation and take this a bit further. So the title of my presentation is Norwegian Child Welfare Cases in the European Court of Human Rights, Some Observations on Values. And I think values is the key word here. As you know, any human rights convention is premised upon a certain set of values. As far as the European Convention on Human Rights is concerned, this set of values is found in the Convention's preamble. And among those we found in the preamble are those referred to as common constitutional values and traditions in Europe. But when it comes to the protection of family life, which is the human rights provision at the center of the child welfare cases against Norway, it might be argued that commonalities may be actually hard to establish. We have a European system that is built on the premise of some commonalities of values in Europe, but if we look closer at these cases, we might spot some dissimilarities value-wise. You know probably that the court is composed of 47 judges. They are each drawn from the 47 member states of the Council of Europe. Obviously, the individuals making up the court in its various formations will represent different worldviews and experiences and opinions on an individual basis, but they will also, of course, bring to the court some sets of societal values that they bring with them from their home countries. So one question is it possible to discern variations with regard to family values and children's rights in the practice of the court in the case law in this field? I think this is a question which, not surprisingly, it's very difficult to find a clear-cut answer to for various reasons. Perhaps primarily because the majority of cases have not yet been decided, so we have not really seen the whole picture yet. But the judgments that have been delivered thus far may give us some clues. which I will come back to. Just to add a few comments on the numbers on this slide. There are now 28 cases that are pending decision at the court, and that includes 4 additional cases that were communicated to the Norwegian authorities in July this year. So the process of continuing to communicate cases against Norway is still ongoing, and it might take a while before we see the whole output of this body of case law. The body of case law concern, or cases concern, as you will probably know, a variety of measures taken by Norwegian welfare authorities and the courts sanctioning them. What I would like to pinpoint to you is what motivates these fairly radical intrusions of the biological family. The third bullet point in this slide. Some of the cases arise out of physical or mental abuse by the parents towards their children. Other cases concern parents with drug or alcohol addiction and problems related to that. But very many of the cases concern cases where measures have been adopted due to, I would say, perhaps less tangible instances of inadequate parental skills, which, according to the contemporary child psychology theories that Norwegian authorities build upon, may also be equally harmful for the child. So we see in many of these measures taken, the decisions taken, that it is referred to insufficient abilities to mentalize with the child. The parent has not seen the child's needs and so forth. And if we take that as a premise and contrast that with who the complainants are, it might be something that we can disclose when it comes to possible value tensions. It is noteworthy that a fairly substantial amount of the parents that have complained to the court have a non-native Norwegian background. They are either of ethnic minorities or they are foreign nationals. And I think it cannot be denied that some of them might find it difficult to stomach the Norwegian authorities' views of what is and what is not permissible in the upbringing of children. That might, of course, include some parents ascribing to using violence in upbringing, but I think more generally and more present is the difficulties of some of these parents to see that this lack of mentalizing with their child is something that might be the reason for this intrusion in the bonds of biological parents and children. And if we accentuate the values question even further, it is very remarkable by all measures in the history of the European Court of Human Rights that other states have opted to intervene on the side of parents and against the Norwegian authorities, even in cases where there are no links whatsoever between that state and the family in question. There are, of course, some cases where states have intervened as third parties in support of the nationals. We have a handful of cases of that particular category, but it is very remarkable and noteworthy that we have this persistent and almost universal intervention by the government of the Czech Republic and the Slovak Republic, and some very conservative NGOs such as Ordu Iuris and ADF International. They have decided to intervene or seek to intervene in almost all cases against Norway, and they present all of them a very strong defense of conservative family values and the sanctity of the biological family. And they appear to believe that Norwegian authorities are representing a threat to those kinds of basic values. We have some other interventions as well, but they are few. I have listed some of them in the bottom of this slide. So we have several avenues that we can take to identify possibly cultural differences that might arise in this body of cases, and the values might differ particularly in how to balance the individual rights of the child as an individual human being and the rights of the biological parents on the other side. And I think if we ask the question, this is me wrapping up my presentation, if we ask the question, can we discern any cultural differences in the court's decisions thus far, I think it is possible to identify some tensions at least. One fairly obvious tension is the weight attached to the value of biological bonds. We saw this in the Strandlobben Grand Chambers case, where the majority favored a so-called procedural oversight of Norwegian authorities' decisions, but there was a very notable minority at the court that favored a more family-oriented world view that they thought should be that the court should impose on Norwegian authorities. That minority view has not prevailed formally thus far, but we see in the practice in subsequent decisions that many of the cases in fact are more of a substantive critique of Norwegian policies in this field than what the Strandlobben case appear to state in its wording. I think it is fair to say that if we characterize the court as a whole, it appears that the whole court has favored some kind of they have favored the biological principle, and they have given that priority over the interest of the individual children in quite a few of the cases. But it's difficult to see how this will pan out when we haven't had the whole set of cases decided yet. The other tension I would like to mention is the weight attached to the interests at stake for the child. And I mentioned this distinction between what forms of neglect or abuse that motivates the authorities' intervention. And in my view, when we see the decisions delivered thus far, we see that the court is less interested in scrutinizing Norwegian authorities when we have the, let's call it old-fashioned abuse and neglect cases with physical violence, alcohol problems, drug abuse. But when it comes to those less tangible, inadequate parental skills, the court is less open to listening to the Norwegian authorities' views in the matter. And I think it might be posed as a question if Norwegian authorities' policy in this field, which is based on well, they claim to be based on very recent psychological models. If this is a view of what is harmful for the child, that has not yet been embraced universally, and at least in all corners of Europe. I think I will stop there. I haven't really taken the time, but I'll stop there, and I will say thank you for the time being.
Thank you so much, Marius, for this interesting perspective. And I'd say over to Ireland, Conor. Welcome.
Okay, thank you very much. Just get my slides lined up here. Not sure if you can see my slides there, and I'm just having difficulty getting them to maximize. Okay, now can you see my slides? Yes, thank you. Sorry for the delay. Okay, thank you very much. And it's a shame I can't be there in Bergen with you all. I really enjoyed attending this event in Bergen a couple of years ago, and hopefully in the not too distant future, I'll be back there with you all again. I'm going to broaden out the child protection discussion a little bit this morning to move beyond the context of child protection in child welfare cases around abuse or neglect in the family home, and to move on to look at broader issues around positive obligations under the ECHR to protect children from risks presented by private actors, be that parents or other individuals who may pose a risk to children's rights under the convention. And those rights might be the right to freedom from inhuman and degrading treatment under Article 3. It could be the right to personal integrity under Article 8. But particularly, I'm going to look at a couple of cases involving the right to life under Article 2. So this whole body of jurisprudence on child protection and the positive obligations of the state to protect children from risks to their rights from private actors has been steadily developing in the last 10 years or so. And on the screen there, I've just given some examples of important judgments of the court, which have established increasingly strict obligations on states parties to take measures to mitigate risks which are foreseeable to children. And I'm going to focus in particular on the last three of those cases with a view to considering the question of how the court deals with the manner in which national authorities exercise their discretion to assess risks, identify risks, and to take steps to mitigate risks. And to look at some of the factors that the court has said should be considered by national authorities in the course of that exercise. And we can, from the case law, extract a number of principles around what factors national authorities are required to consider. And these include the rights of the child which are at issue, which I mentioned a moment ago, be that Article 2, 3, or 8, the nature of the risk which is posed to those rights, the level of the foreseeability of that risk, the reasonableness of the measures which might be required of a state party to mitigate that risk. The court obviously accepts that not every risk can be prevented, and that the court needs to be aware of the importance of avoiding putting impossible burdens on national authorities to try to prevent every possible risk which might arise. We also see in some of the cases that we'll be discussing in a moment the question of the extent to which the rights of others might be restricted by the measures which must be taken to mitigate the risk. And then the question of how those rights could be balanced. If the rights of the child need to be weighed up against the rights of another party, well, then how do we ascribe priority between those rights? So we're going to see a number of cases which look at these factors and weigh them up in different ways, and then pose questions at the end really about how much weight the court requires to be ascribed to each of these factors. But running right throughout this case law is the question of discretion, and the court repeatedly emphasizes in the case law the importance of affording discretion to national authorities and avoiding substituting the court's own judgment for the judgment of national authorities. So, for example, in Talpas versus Italy in 2017, you see there, I'm not going to read all these passages, I'll just leave them on the screen, but the point being made repeatedly in these cases is that the court is emphasizing that national authorities must be afforded discretion to make their own judgment about how best to weigh up risks and how best to discharge their positive obligations under the convention. So that point was stressed in Talpas in 2017, stressed again in Strand-Lobben, which was already mentioned in both of the earlier presentations. Strand-Lobben, the court saying there that it's not, the court's task is not to substitute itself for the domestic authorities in the exercise of their responsibilities. So that idea that you must leave room and space for the domestic authorities, give them the margin of appreciation to make their own judgment about what their obligations require is a very important theme of this case. So, and in Strand-Lobben, the court mentioned here that the margin of appreciation to be accorded to the national authorities will vary in light of the nature of the issues and the seriousness of the interests at stake. The court thus recognizes that authorities enjoy a wide margin of appreciation, but this is not unfettered. And a lot of the cases turn on this tricky and difficult question of how far does the margin of appreciation go? How much discretion should national authorities be given? And where are the limits of that? And what I'll be saying in a moment about some of the recent cases is that it can be quite difficult to identify in a coherent way, looking across judgments, the exact point at which the margin of appreciation runs out and the exact point at which the court will start saying, well, actually, we're not going to say that this was a matter of discretion for national authorities, but in fact, they went beyond their margin of appreciation and failed to exercise their discretion in a manner which discharges their positive obligations under the convention. So a couple of cases that I'm going to look at to illustrate some of the difficulties in weighing up these different factors and trying to judge that question of the scope of the margin of appreciation and the level of discretion that states parties have. Talpas versus Italy was a domestic violence case. It was a case in which there was a history of domestic violence and multiple complaints made by a woman to the police regarding incidents of domestic violence at the hands of her ex-husband against both her and her son. And this culminated ultimately in one night where there had been an incident in the family home. The police were contacted, and when the police arrived, at that point, this woman, the mother and her son both told the police that there hadn't been any violence, simply that the father was drunk and that they felt he needed a doctor and needed medical attention. So the father was taken to hospital. He then subsequently walked out of the hospital, was stopped by police at 2:30 in the morning, and there was an identity check, and he was then fined and released again by the police. And at 5 a.m., he entered the family home and stabbed the boy and the mother, and the boy died. Now, in this case, the court ultimately found that Italy had failed in its positive obligations under Article 2 to protect the right to life of this child. And looking at this, the court took an approach which really emphasized the rights of the child, which emphasized the importance of looking at the contextual factors in the case, the history of domestic violence, and how all of that fed into what ultimately happened on the tragic night in question. So we see here the court saying that the risk of a real and immediate threat must be assessed taking due account of the particular context of domestic violence and the recurrence of successive episodes of violence within the family unit. So that history and that contextual factor, the court felt was very important and something which hadn't been adequately taken into account by the authorities in Italy. And the court reiterated that in domestic violence cases, perpetrators' rights cannot supersede victims' human rights to life and to physical and psychological integrity. So we see there, going back to that list of factors I mentioned earlier on that the court has identified that should be taken into account, we see in Talpas the court placing a lot of weight on particular factors there, in particular the rights of the victims in this particular case and the rights of the child. And then this tees up the cases that that really led me to put this presentation together for today, which is two cases from the past 12 months. both of which concerned incidents of school shootings. And so these two cases were Kotalainen versus Finland from September of 2020 and Kurt versus Austria from June of 2021. Kotalainen involved a school shooting where 9 students and 1 teacher were killed in that school shooting. Compared to the Talpas case, which I just mentioned, there hadn't been any particular history of violence on the part of the perpetrator. There was no specific threat made around that school shooting. What there was evidence that the perpetrator had an interest in mass shootings. He had posted videos on the internet, which gave the impression that he was interested in this. The police had the opportunity to seize his weapon, but they chose not to. They interviewed him and they cautioned him, but didn't take his weapon. And the next day he carried out this shooting. And in Kotalainen, the court found that that was a violation of Article 2. The court, and I'll come to some of the reasoning there in a moment. Kurt versus Austria then, just a few months later, a father who had shot his son dead at school, who had a history of domestic violence similar to Talpas. There had been multiple incidents of domestic violence against both the child's mother and the child. There had been multiple death threats made by the perpetrator against both the mother and the child. But unlike in Talpas, there had been a barring order in place. And unlike Kotalainen, there was no registered weapon held by the perpetrator in Kurt. And in Kurt, we'll see the court ultimately found, a majority of the Grand Chamber found there was no violation in Kurt. 10 of the 17 judges, 7 judges strongly dissented. And so these cases pose interesting questions about the weight to be ascribed to these different factors that I mentioned earlier on. How important is it to look at protecting the rights of the victims and giving priority to the rights of the victims over the rights of the perpetrator, compared to, on the other hand, how important is it to afford discretion and space to national authorities to make these risk assessments and to weigh up these factors for themselves. In Kotalainen, I guess one factor in Kotalainen which was important was that there was a pretty straightforward way available to have prevented the shooting. If the weapon had been seized when the police had the opportunity, then the shooting would not have occurred. The court noted that, said this precautionary measure was available, was considered, but wasn't implemented, and that this wouldn't have entailed any significant interference with any competing rights. So ultimately, the ECHR rights of the perpetrator weren't particularly under threat in Kotalainen had his weapon been seized. In Kurt, on the other hand, we see a different approach. And in Kurt, of course, it would have been somewhat more difficult to prevent the shooting in Kurt. It must be said, there wasn't such a straightforward intervention available that could have prevented the shooting. The majority of the judges in Kurt emphasized the fact that there had been a swift response to all the allegations of domestic violence. There had been a barring order in place. There had been a risk assessment, and repeatedly said that there was no particular indication that there was a risk that this father was going to shoot his son. The police had checked to see if he was a registered weapon owner, and he wasn't. And so ultimately the majority, looking at these factors, found ultimately that the authorities had exercised their discretion in a way which discharged their duties under Article 2 of the Convention. But it's interesting if you compare the majority judgment of the 10 judges in the majority to the very strong dissent from the 7 judges in the minority, who took a different view. They said, we consider that the assessment of the lethality risks was inadequate as to its substance, as the authorities unjustifiably overemphasized certain factors and underemphasized others. So they pointed to the fact that the repeated death threats which had been made against the mother and the child in this case had not been paid much attention by the authorities. The fact that there was no separate risk assessment in respect of the child, the fact that the barring order was very difficult to implement in the school context because there was no law allowing for the details of that to be communicated to the school. And so the dissenting judgment took a much closer look at the manner in which discretion had been exercised by the national authorities. Whereas the majority judgment, if we go back to the question of the rights of others and the rights of the perpetrator, the majority judgment had emphasized very much that in order to prevent the shooting from having happened in court, any measures taken would have had to restrict either the freedom of movement of the perpetrator by preventing him from going anywhere near the school, or alternatively to take him into some form of preventive custody, which would have involved a deprivation of his liberty. So there was a strong emphasis in the majority judgment on the restrictions of the rights of the perpetrator, which would have been entailed. Whereas the minority judgment is much closer to what we saw in Talpis in emphasizing, well, ultimately the right to life of the victim is what really needs to be given priority here, and that should take priority if necessary over the rights of the perpetrator. And so the dissenting judgment in court says it's not the court's task to indicate the precise measures which would have been appropriate in hindsight. It is up to each state party to adopt its own legal standards, but provided that they provide the authorities with an adequate range of operational tools to prevent or at least sufficiently mitigate serious attacks on life. So again, this is this whole balancing act that we see in these cases, that yes, on the one hand, the court must give space to national authorities to make their own assessment, but on the other hand, the margin of appreciation has its limits. There comes a point where the margin of appreciation must run out. And the tricky thing is deciding where is that point. The majority felt that the Austrian authorities had operated within their margin of appreciation, but a sizable minority in courts deciding that there were additional measures that could reasonably have been taken to protect the life of the applicant's son, and concluded therefore that Austria had violated Article 2 and failed to discharge its positive obligations. So where does this leave us? I think what we see from these cases is that there is a degree of consistency between these cases around establishing what factors national authorities must consider in weighing up risks to children's rights and deciding whether or not there is a need to take steps to mitigate a risk. So we know which factors, but what is unclear from the judgments is how much weight should be given to each factor. We see in Talpis and Kotalainen, the emphasis was very much on protecting the rights of children, giving priority to the rights of children over the rights of the perpetrator if necessary, looking at these broad contextual factors rather than just the specific risks. So saying, as long as if we see there is a general risk existing, that is enough to trigger the obligation to act. Kurt, on the other hand, placed much more emphasis on the discretion of the state authorities to carry out their own assessment of risk. On the issue of the specific risk rather than a general risk, they really kept coming back to the idea that there was no particular evidence that this perpetrator was going to go to this school and shoot this child, which is quite different to the more general approach to risk in Talpis and Kotalainen. And the rights of the perpetrator, again, being emphasized in the court judgment in a way which is perhaps somewhat different to Talpis in particular. So the majority in court, I think, we see a different approach, a different weight being ascribed to the factors. The minority in court aligning more closely probably with Talpis and Kotalainen. But all of this raising questions really about when it comes to deciding how much weight do we apply or do we ascribe to each factor, how much discretion do we give to national authorities in these cases. These cases are difficult because in some ways they raise questions and make it difficult to predict with certainty how the European Court of Human Rights would approach other similar cases in the future. So I see my time is up. I'll stop there, but I'm delighted to discuss all of this further. Thank you.
Thank you so much, Connor, and to all three panelists. Katra, can I now ask you to just very, very briefly pick up maybe the main points of these three presentations that were slightly different in the topics they discussed before we then open up for some questions?
Yes, good morning. I hope that you can hear me. Yeah, perfect. It is very interesting because I think that there were actually a lot of common themes in all of these three presentations. They all discussed state discretion, and also they all hinted the possible harmonizing force of European Court of Human Rights judgments and the way that it tries to create this kind of European level value system, and therefore we also have these conflicts. And at the same time, they also showed, I think, the way that the European Court of Human Rights currently is a actual lawfare battleground where these value conflicts are playing out. So Karl Harald started with the Kia order cases against Norway and pointed to the substantive value conflict between this kind of long-term placements versus then care order as a temporary measure. And it is interesting, I think, the way that the substance of the disputes actually hasn't changed since Johansson. So we are still, for the last, how many years is it now? More than almost 30 years, but not 25 years, yeah? We have discussed the same principles, the same values. And the court is taking a different approach. Garhara said that Norway is following the judgments of the court. I have a question mark here. If the value conflict is still the same, then can we actually see that the member states, especially where there is such a big discretion on the county board level, follow the judgments of the European Court of Human Rights? Then I think that Marius brought out this kind of additional layer of the dispute or of the lawfare, where we have now third countries participating very strongly on behalf of the traditional values or on behalf of the Norwegian government in these child protection cases. And also interestingly, the way that the court has allowed NGOs, especially the strong Christian NGOs, to participate in this discussion. The court does not have this obligation. Only states can pro forma participate as third parties. And it is also interesting what is missing here, I think, the fact that there is no special separate representation of the child in these cases. You did not point that out, but in a way there is a party missing, I think. And Conor then expanded this kind of discussion of values further and asked what the positive obligations of the states are in protecting the child from the harm. And for me, the most important lesson was, or question was, to what extent can we preemptively limit different rights of persons in order to protect the child from harm, in order to make the risk assessments and take preemptive measures before this kind of horrendous acts happen. So in a way, there is unbalanced the rights of the child on the one hand and the rights of others on the other hand. And how do we balance them? What importance do we grant to different rights? So I think that there were many common themes, but perhaps before we ask the questions, then the panelists might want to respond to each other. So let's, if you agree, Amy, then let's give each and everyone very short, perhaps 2-3 minutes time to respond to the others.
If anyone wishes to do so. Maybe our virtual panelists first. Marius, Conor, do you want to comment on anything that's been said, or?
I can start if you allow me. I think it's easiest to comment on Conor's intervention because he brought to the table parallel cases, which I am also intrigued by from the perspective of these Norwegian child welfare cases. I think it's what strikes me is that the court has not at all coupled the strand of cases that concern, for instance, domestic violence and child welfare cases in any of the recent judgments that we have seen from our viewpoint. From the child's perspective, it might be very irrelevant if a case is categorized as a domestic violence case or as a case where parents have, through violence, neglected their parental responsibilities. And we have, in fact, tried from our office in our written observations to the court, tried to convince the court to take this broader perspective, but they have not been willing to take up that mantle. So I think it's fascinating. Let's put it like that.
Thank you.
Yeah, I mean, to respond to that quickly, I mean, my impression overall, looking at all of the domestic violence case law of the court over the years, and there were other cases which I didn't mention in my presentation, but a lot of the domestic violence case law, to my mind, takes an approach which maybe imposes higher standards and higher obligations around the expectations on states parties. The child welfare case law maybe is more cautious, perhaps, because it's very conscious of the family life dimension and the restrictions on Article 8 that will flow from state interventions. And I think it's a good point you make, Marius, that some of the domestic violence case law, and there's other cases like Koncova versus Slovakia or Iremia versus Moldova that I didn't mention today, but some of those cases are less concerned about the Article 8 dimension and the idea that there will be restrictions on family rights, and more concerned about ensuring that the rights of the victims are protected. Now, perhaps that's because you have a situation where you have it between the parents, as it were. So it's easier to say we must restrict the rights of one parent in order to protect the rights of the other parent as well as the child. Whereas if you are restricting potentially the rights of both parents just to protect the rights of the child, the numbers sort of break down a little bit differently. But what struck me there, I was taken by the point that Katja made in response to Carl's paper about the fact that these cases, the child welfare cases and the Norwegian child welfare cases, have been having the same debate for 20 years. I thought that was an interesting observation, and it does raise questions about why is that. I guess I'm interested from a Norwegian perspective to what extent is that down to the fact that things in Norway maybe haven't changed enormously on foot of those judgments, or is it something else? Is it just that this is just the inherent nature of these cases? And something that struck me reading the court judgment in particular was that sometimes these cases are just hard. Sometimes there aren't clear answers, there aren't bright lines that we can draw around what the right thing to do is and what the wrong thing to do is. I do find myself wondering sometime in cases like Kurt or cases like Strandlobben, will those cases always be a 10-7 or an 11-6 or whatever it is, because they're just hard cases. And when you get a court coming in years after the event with the benefit of hindsight and deciding what should or shouldn't be done, that there's always, as much as the court tries to say we're not going to impose hindsight, the judges are just human and they will always impose hindsight to an extent. So I wonder, how much is it just that this is the nature of the cases and they will always lend themselves to this, or how much is it that these cases keep coming to Strasbourg because maybe there are things that could have happened in Norway, for example, that haven't happened in the last 20 years.
Thank you, Gunnar. Maybe you want to say
something? I try to be very brief. First of all, when it comes to Katja's comment about has anything changed? Yes, it changed when it came to adoption. The adoption rate in Norway significantly fell after 1996. Of course, I cannot say that there was a that this was not a coincidence, but it was a significant one. Secondly, I think it's important that we all discuss the balance between the children and the rights of the parents. I think it's interesting that you can count the number of interventors and so on, but I think if you read the judgments and you see how much space is used on the parents' position, how much space is used on the children's awareness of how they experience the situation, I think that will be interesting, because you see that there is a tendency to pay more attention to the parents' perspective, also when it comes to that the parents can intervene on behalf of their own children. The last point, I think there is a tension here, but I think it's also interesting to see when it comes to care orders, the court is rather firm that they are not overruling the care orders, even though they are based on this more kind of emotional approach, as Marius mentioned. Thank you.
Thank you very much. So I'd like to open up for questions. Yes. Thank you very much. I think this is just, I think you have to come forward here so we can all hear you.
Thank you very much. I think this is fascinating, and I really agree with Connor that these must be some of the most difficult cases imaginable, as far as I can see. I want to ask, well, first I want to get clear, because I don't know whether I'm being a good enough mother. I don't know what mentalizing with a child means, so maybe you can say a few words so that we're just up to the Norwegian standards. And just out of, this is not a provocation, it's just a genuine curiosity. Do Norwegian authorities, when assessing the recent psychological views on parenting, compare those with psychological assessments of foster care and you know, so basically I see a risk of idealizing what parents can do in terms of good parenting, but then maybe idealizing the kind of care that children get in foster care. So the psychological assessment is that, does it happen on two tracks? But those are just factual curiosities. My comment goes, and I see that, and I think it came very clearly in Maria's intervention, this idea that there are different worldviews around these issues, and you know, the third party, the state parties intervening. And I would say that the countries you mentioned and the Ordu Iuris would you know, affirm a kind of sovereignty or property paradigm. This is not the paradigm I want to second. So this is not where I'm coming from. I'm coming from the care paradigm, but I'm asking you whether in what is proper care in any of these cases, well, the multicultural dimension has really been engaged with, you know, that there really are cultural differences about what care is and how care should be done. And of course, we can all maybe agree that violence shouldn't be part of that cultural exceptionalism. But even that leaves a wide margin as to what proper care and cultural variation is. Has this really been seriously been engaged with in any of the cases? And the second question about what care is and what care duties should amount to has to do with the gender analysis of this. And I find very interesting that in none of your interventions, the fact that often it's single mothers and poor mothers, you know, that are affected by these decisions. And this hasn't really come very much to the fore. So is the, you know, proper or the duty of care, how is that taken into account with what is reasonable to expect from mothers? And is it, I don't know, is there any assessment that goes along the lines of what the state provides in terms of assistance to motherhood? Or is this just some absolute standard and you say, well, you're not a good enough mother because you do all these wrong things, and I don't care whether you're, you know, what your conditions are or whether the state is living up to its positive obligations to assist you, you're simply not a good enough mother. So those are some of my concerns, and I wonder whether you can give me some comments. Thank you
So much. Very important and interesting questions. Can I ask our panelists maybe respond succinctly to this so we have space for some other questions? Does anyone want to go first on this?
I can go first again.
Thank you, Magnus.
As far as mentalizing is concerned, I'm not sure if I can precisely convey the meaning of it. So I think it's something to do with your ability to see the child's perspective, and the mentalizing concept is one of several concepts that the Child Welfare Service uses as tools in their assessments. And I just mentioned it because it was something that I hadn't heard of prior to my engagement in these cases as well, and it seemed to be some kind of lingo in a particular profession that is quite difficult to disentangle. So I think, but it's something to do with emotional inadequate emotional skills, just we can put it like this, I think. Has the multicultural aspects been addressed by the court? I think the answer to that is no, not in a direct way thus far. We have this grand chamber cases of the Ibrahim, which is not yet delivered, where this might be addressed by the court, and we have some other cases down the line that might also be interesting, but thus far the court has not been engaged in the multicultural aspects as such. Are single mothers or poor mothers exposed disproportionately in decisions by Norwegian authorities? I think not. At least that's not my impression when we see statistics and including the cases brought before the court. But I might be wrong. But I think it's not my impression that single mothers or women are judged more harshly than men or more affluent parents. So, yeah.
Thank you.
Yeah, to follow on from that, I mean, I agree that the multicultural question is a very interesting one, and it's, you know, it's likely to find its way to the court, I think, at some point in the future. Certainly in Ireland, we do see that there are overrepresentation of certain cultural groups in the care order statistics. People of African origin, for example, there's an overrepresentation there, which has been sometimes associated with different cultural norms around corporal punishment and that sort of thing. There's also an overrepresentation of members of the traveling community in Ireland being sort of Irish. Well, gypsies probably the word often used around the rest of Europe, but we call them the traveling community here in Ireland. But people living often in mobile homes or caravans in quite poor conditions, and that's it's a cultural thing. They travel around, but that does lead to overrepresentation in the care statistics. So you know that's been identified in research in Ireland, and I'm sure it's similar in a lot of countries. So I think that is something the court is likely to grapple with at some point in the future. On the question of single mothers and the impact of poverty and so on, that has been addressed by the court. There's a couple of judgments which have looked at this. In particular, there was a judgment in 2013 called RMS versus Spain, in which that involved a child who had been taken into care and ultimately placed for adoption. And the evidence was that poverty was a big driving factor behind the decision-making of the authorities in that case, and adequate measures hadn't been taken to try to provide support for the mother, and the court found a violation in that case on the basis of those factors. So there is ECHR jurisprudence addressing that point, and I think addressing it probably with the correct perspective as well.
Thank you so much. Are there any further questions in the audience, or Katja, do you have any questions online? Yes? No?
Unfortunately, no questions online.
Because that's perfect, because I actually have a question that I'm burning to ask. So we talked a little bit about third-party interventions, and I'm wondering what the panelists think about sort of whether this is actually a useful mechanism. Because to me personally, it seems like a terribly intransparent thing that we have. And I mean, Marius, you mentioned that some of the organizations are somewhat extreme in where they're coming from. And as Katja pointed out, the court is not obliged to actually accept these interventions. So the question is, on what basis does the court even choose who is allowed to intervene, apart from the member states who are allowed to intervene by default? But also, should the court maybe actually invite certain experts to comment that are sort of maybe more reputable, maybe come from the research community or more neutral? And also at the same time, where's the child in this? Katja mentioned this before. There's no independent representation of the child by default in these cases. And couldn't this be covered by some organization maybe that actually gives the opinion from the child's perspective? So are we missing something? And why do we not see this at the public? Where's sort of the democratic process in this? And since the topic of Bergen exchanges is lawfare, is this not a way of maybe weaponizing this mechanism in the interest of a political agenda, especially in light of what Connor said, that the court is also just human. I mean, they might say they're not influenced by this, but you get these lengthy interventions, and this might well have some kind of impact. So what are your thoughts on this as a mechanism? Carl, maybe
Yeah,
you say something?
I can start. First of all, I think it's interesting, and I think that we should be in mind that those intervening in the case, either parties or third parties, or also the parents when they are intervening on behalf of their own child, I think it matters to a certain extent. On the other hand, I think that the court is also mindful about this. I think that they know there is a certain risk. I think it's interesting to see, if you take for the last 20 years or 25 years, you see that there is an increased attention within the court to use the language of the UN Convention on the Rights of the Child. They refer to the convention. I think it's not just only on the surface. I think it also has a kind of impact on the case law of the court. But of course, it's difficult to kind of assess, how deep does this impact go? But there is a certain development. I think it's also very interesting if you, of course, you have so many cases, and if you try to find a system here, it goes not in a straight line, and you think it goes like this. And I think that will continue, because there is different approaches. If you just not take child protection cases, but if you are in Europe and you have a discussion with colleagues, and they say that to slap a child like this, in many countries, that's fine. But if I go to a lunch here in Norway, say that normally I do this with my children, well, it will be rather problematic, because that will be seen as something that you don't do as a parent. Yeah.
Thank you. Mario, so do you want to comment, maybe? Briefly, we only have a few minutes left, but...
Yeah, well, I can just say that you asked on what basis the court decides who can intervene, and the answer is we don't know at all. It's up to the section president's discretion, and that's something that they keep to themselves. I generally am not in favor of these amicus briefs in court proceedings at all, but the fact is that the treaty has a provision in Article 36 which allows for this for states, and states are entitled to intervene if it concerns their own nationals, but in other cases they are just any other third party, and the court had to agree on those interventions as well. So it's a bit intriguing to see that the court has opted to allow the Czech and Slovak republics to intervene, although they're not entitled to allow them to do this in all cases. As far as child representation is concerned, let's say that I share your concerns to some extent. We have seen a couple of cases where the adoptive parents have intervened as third parties. The Strandlobben case is one case in point, but this is a felt need, I think, from several organizations working for children's rights. But it's also interesting that none of the NGOs working for the interests of children have decided to intervene in any of these cases, even though they have been encouraged to do so by several people, and they are very much aware of the body of case law. So that's for them to respond to, I think. Thank you.
Thank you very much. And I guess we're out of time. No, okay, very briefly.
Very briefly, I am in favor actually of the third-party interventions. I think that they can bring a lot of deep expertise on specific issues to the attention of the court in a case where perhaps otherwise that might not reach the table in the decision-making process. Perhaps we could structure it more effectively and more transparently. I would agree with that. But the court judgment, which I discussed in my presentation, was a really interesting example where there were many third-party interventions actually by a lot of organizations working in the area of domestic violence. Some of those are very high quality. Now, different emphasis was placed on different interventions by the majority and the minority. But to my mind, that case is an example of where those interventions put better information and better quality data at the court's disposal to assist it in its decision-making process than might have been the case if they hadn't been allowed.
Thank you so much. And I guess with this we wrap up. Thank you to everyone, to the wonderful panelists, Katra, the audience here and the audience online.